Hello friends, today I am going to talk on the law of wills. As far as Hindus are concerned, they are governed by the Hindu Succession Act as also some of the provisions of the Indian Succession Act. But here friends, as an advocate, I would like to state that in my years of practice, I have seen that many people are not ready to make a will. They fear that if they make a will, they will lose valuable rights in their property. But a will comes into operation only after the death of a person. So in your lifetime, you can enjoy your property and also make suitable arrangements of how and in whom it is to be distributed after your death. The legal definition of a will is that a will is a legal declaration of the person making the will in regard to his property which is his own or in which he has some right. So that means that you can make arrangements of how your property is to be distributed among your kith or kin or any other person, maybe some faithful servant or some any other person whom you wish to give something by way of your will. If you do not make a will, it could be said that you died intestate. It means that you died without making any testamentary arrangements about your property, and then your property will be governed by the personal law of succession to which you belong. So it is very advisable, and who else but an advocate could tell better the importance of making a will. Now the next question is, what is a will and how is it to be made? There is no specific format of a will given in law, but broadly there are three parts in a will. The first part is the introductory section. In that part, the person making the will gives a brief description of himself, that is his full name, his age, his business, his residence. Then comes the description of all the assets owned by the person. When I say the assets, it means the landed property, the bank deposits, the shares, the gold ornaments, the cash lying with the person, or any such valuables which is the property of the person making the will. He ought to give a very precise description of his property and assets. Otherwise, subsequent to his death, his will may be challenged and may lie dormant in courtrooms for years together, and the real beneficiaries will be put away from enjoying the fruits of the will. So, the description of the property needs to be given in a very precise manner. For example, he could say that I have landed property at village so and so, state so and so, and measuring about so and so, and my share in that property is say half. Next part should ideally be the description of the beneficiaries to the will. In that part, the testator, that is the person making the will, should give a brief description of his beneficiaries, the relations which he has with them, their exact age, their full names and not their nicknames need to be given. There should be no confusion in the mind of the executor or any other person about to whom the bequest has been made. For example, he could say that my agricultural land situated at XYZ place is hereby given by this will to my son ABC. My flat in society such and such, admeasuring so and so, is hereby given by will to my daughter, and so on and so forth. This is the main body of the will, and it needs to be given in a very precise manner to save any further legal complications which could arise later. The third part of the will is the concluding part, in which the testator ought to say that this will is being made by his own free will. There is no any force or pressure exerted on him by anybody in making the will. Then he has to say that he is in a very sound state of mind while making a will. It is also necessary to mention in the will that this is the last will of the testator. This is necessary because according to law, the last will of the testator always prevails over any previous wills made by the testator. Dear friends, I want to state that though there is no definite format of making a will, these are some of the very necessary ingredients which ought to come in a will. There is no specific stamp paper or any court fees required while making a will, but these things need to come in some specific order to bring clarity to the persons who are going to be the beneficiaries and to the persons who are going to execute the will. Before going further, the question would be that who can make a will? A will can be made by any person who is in a sound state of mind and who is not a minor. When I say sound state of mind, it means that the person making the will should be in a state of knowing what he is writing and what is exactly the legal repercussions that are going to follow. If a person is in a heavy intoxication, he cannot be said to be in a sound state of mind. Sometimes some very senior adults are losing memory and they are having lapses of memory. So they cannot be said to be in a sound state of mind at that time. But when they are in a proper state of mind, any will made by them is very much valid. After writing all the contents of the will, the testator has to sign right below the will and ideally on every page of the will. We always advise the persons making the will to sign on the joints of every page so that there will be no change by anybody in the pages and the contents of the will. That is the most safety measure we advise as an advocate to our clients. One more thing I want to state is that ideally we always advise that when a person signs below the will, we always advise them to affix their own thumb impression on the will. This is just out of abundant precaution in case the will is challenged after the death of the testator. Thereafter, the will needs to be attested in the presence by two witnesses. It is very necessary that the testator sign upon the will in the presence of these two witnesses. The witnesses should be totally independent person having no concern whatsoever with the property of the testator. That is, they should not be the beneficiaries to the will. They should be totally independent persons. They may be some near friend or some neighbor or anybody whom the testator trusts. A very practical advice here is that witnesses need not be very aged persons and they should be in a proper condition. They need to depose in court if tomorrow the will is challenged. Now, some people have a question whether a will is to be registered compulsorily. Whether to register a will or not is your own free option, but according to law, a will is not compulsory registrable. But we ideally advise that the will be notarized before a notary public. The person making a will also needs to appoint an executor to his will. Now, what is an executor? An executor is a person who will execute the will as per the wishes of the testator after his death. Therefore, some specific person or persons need to be named as an executor to the will. Normally, the person making the will hands over the original of the will to this testator, gives him or her instructions that the will should be read after say 4 days or 8 days of his demise in the presence of all the concerned. Ideally, the testator also needs to make provisions for his funeral expenses as also for the fees of the executor. Here I would also like to state that not only assets but the testator can also make a provision for paying off his debts and liabilities in the will, and instructions to the beneficiaries how his debts are to be set off or are to be paid. Now here a question will arise that supposing a person wants to make any change in his will or add something or delete something, what is the provision? So here I would state that a person can add, alter, amend, modify his will, his present will in the way he wants, and again go through the similar procedure as while preparing the original will. In the alternative, he can also make a totally new will, and after writing all the other recitals, he has to state any previous wills of his stand automatically revoked by the execution of the present will. The will can be written on any piece of paper. It can be handwritten by the person making the will, or he can get it typed, or even he can get it written from anybody else. There is no hard and fast rule while making a will. Friends, life has become very uncertain. So is it not advisable that you secure the lives of the people who are going to survive you and make provision for their security? If you do not make them, then you will be governed by the rules of succession of your own personal laws. But then you will be left with no choice. Your assets will be governed by the rules of succession of the personal laws which govern you. So it is always advisable to make a will, but with abundant care and caution. It is necessary to obtain a probate by Hindus for giving effect to the will, though nowhere specifically stated. When after a will is prepared, at the last page of the will, we advise that the person making a will obtain a certificate by a medical practitioner, ideally an MBBS doctor, and he give a certificate under his own writing and seal that he has examined the person making the will and he is found to be in a proper state of mind and very fit at the time of making the will. This is just one legal formality to show that the person making the will was very sound state of mind whilst making the will. Wherever applicable, the executor has to obtain a probate to the will. Now what is a probate? Let me read it out to you. What is a probate? A probate is a certificate issued by a court that the will of the deceased is legally valid and that the executor appointed under the will is authorized to administer his or her estate. That is what a probate is. So the executor, wherever applicable, has to obtain a probate of the will, and only then the executor can administer the estate of the person as per his wishes. Friends, in these uncertain times, it is very necessary that one makes a will without hesitation to manage and distribute his assets after his or her death. This is a very basic information I am giving you about the laws governing the wills. There are many other aspects to it, but for basic understanding, according to me, this is sufficient. In spite, if you have any queries, please write in the comment box below and I will try to answer your queries to the best of my abilities. I have also given my email address in the description box below. You could even write to me on my mail address for any queries and difficulties you have regarding this topic. If you liked my video, please don't hesitate to like, share and subscribe to my channel.